Thank you, Amelia, and good afternoon, everyone. Thanks for joining us today. As you are no doubt aware, the original $349 billion that was originally earmarked for the funding of the Paycheck Protection Program loans was exhausted as of late yesterday morning, and further applications are no longer being accepted by the SBA. Heated negotiations continue between the branches of Congress and the White House, even as we speak, to try to reach an agreement on an additional $250 billion in funding, but as far as I know, no agreement has yet been reached. According to the statistics that have been provided by the SBA, as many as $1.6 million in loans, 1.6 million loans have now been approved with an average loan amount of approximately $240,000. It appears that construction companies have been the largest beneficiary of the program so far, with real estate and rental companies trailing pretty far behind at less than 4% of the total loan pool. Although loans approved but not yet funded prior to yesterday's cutoff are not in jeopardy, it's unknown at this time whether pending applications, which have not been approved or issued a loan number, will be handled. We are optimistic, as I think we all are, that agreement will eventually be reached in Congress and with the White House on the new appropriations, and that the SBA lenders will begin to commence reprocessing of applications and taking new applications. We certainly hope the information we're providing today will be helpful. Some of it may be somewhat basic if you're well versed in this, but we hope to shed some additional light on things that may be of help in that process. And if you have already obtained a loan, in the process of determining the loan forgiveness aspect of the program. So let's start by taking a look at some of the basic information on the Paycheck Protection Program, or the PPP, including eligibility of borrowers, counting employees, calculating loan amounts, the affiliation rules, application process, and of course, as I just mentioned, the loan forgiveness aspect. Along the way, we're going to interject some of the commonly asked questions that we've been getting from our clients and other parties about interpretation of various provisions of the Act and the guidance that's been issued. So, as I mentioned before, the Paycheck Protection Program was originally allocated $349 billion, which has now been allocated. And the idea was to expand the existing SBA 7A loan program so that the Paycheck Protection Program loans could be quickly delivered to small businesses to help them cover their immediate needs for payroll costs and other limited business expenses as a result of the coronavirus crisis. Borrowers are not required to provide any collateral for the loan or personal guarantees, and will have the benefit of a 6-month deferment period on payment of principal. It's important to note that interest will accrue during that 6-month deferment period, however. Interest will be accruing on the loans at a rate of 1% per annum, and the loans will have a maturity of 2 years. As we'll discuss in more detail a little bit later, if the borrower is able to prove use of the proceeds within the established parameters, they will qualify for forgiveness of potentially the entire principal amount of the loan, but we're going to look at some scenarios where it may be difficult, if not impossible, to qualify for 100% of the loan forgiveness. As I think everyone is also familiar with at this point, the Paycheck Protection Program originated under the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act, which was enacted on March 27th of this year. Since the date of enactment, the SBA and the Treasury Department has issued various rules, frequently asked questions, and additional materials, which you see listed on the slide here. I won't go and list each of those in detail, but it's very important to keep in mind that if you're looking at issues or you're interpreting the various provisions of the Act, you need to also be looking at the interim final rules as well as the FAQs, because they are very helpful in providing interpretation of the Act, and in some cases changes certain provisions of the Act. So it's necessary to reconcile a lot of this information and look at the total picture rather than any one particular part of it. So now let's look at eligibility, and for that I'm going to pass it over to my colleague Allison Markovich.
Thanks, Doug. As Doug has previously stated, we know that the funds at this point have run out. So I don't want to spend too much time going through eligibility and things like that. Of course, we're always open to answering specific questions if you are in the process of receiving a loan or have received a loan or are questioning whether or not you are actually eligible, but you did apply for a loan. So I'll be brief in discussing eligibility. We are hopeful that more funds will be allocated. So if you have not yet applied, this information could be helpful for you. Generally, a borrower is eligible if they have less than 500 employees. There are exceptions if the SBA employee size standard allows for more than 500 employees. For example, a dog and cat food manufacturing allows for 1,000 employees under the SBA size standard. It was originally unclear if the definition of a quote-unquote small business concern was being expanded to get rid of the revenue test in a traditional 7A loan in order to determine if you meet the small business concern definition. You would look to see if your industry is either a revenue test or an employee test. So it was unclear if they were eliminating the revenue test altogether. But based on the Department of Treasury guidance, it has been confirmed that a borrower may also be eligible for the PPP loan if they meet the revenue-based size standard for their industry. So for example, a hotel has a $35 million annual receipts, and that's a defined term, which does have a separate definition, but is basically amounts to gross revenue. The last way a borrower is eligible is if they meet the alternative size standard test as of March 27th, 2020, which is if they have a maximum tangible net worth not more than $15 million and the average net income after federal income taxes for 2 full fiscal years before the date of the application is not more than $5 million. There are some additional eligibility requirements. The borrower had to be in operation as of February 15th. The borrower had employees for whom it paid salaries and payroll taxes, or paid independent contractors. I want to make a distinction here that independent contractors are in fact included in your calculation for employee size, but are not included for your calculation of payroll expenses, which we will discuss later. And then sole proprietors and independent contractors, as well as some nonprofit organizations would also be eligible, but we're gearing the webinar towards small businesses, and so we won't go into too much detail surrounding those eligibility requirements. So a big question came up is, how do we calculate employees? At this point, most of you have probably already submitted your application, but note that the SBA has shifted this burden of calculating employees to the borrowers. We've had a lot of questions regarding how to determine if a business has less than 500 employees. The additional guidance that was issued after the Act helped, but unfortunately, a lot of applications were already submitted. What it said was that the borrower could use the traditional SBA test, which is the average number of employees per pay period for the 12 completed calendar months prior to application, or if not operational for 12 months, then the months the business was operational. The borrower can also use the average employment over the last 12 months or calendar year 2019. We would note that that employee calculation should coincide with how you also used the payroll calculation if you used the last 12 months or calendar year 2019. We have heard that some lenders were requiring borrowers to report at how many employees they had at the date of application, which arguably could have put the borrower reporting less employees than their average because of layoffs. We believe it's still prudent to stick to the SBA guidelines, but the guidance did specify that if a borrower does not need to amend their application if it was filed prior to the guidance being issued.
Thanks, Allison. So let's assume I am a small business and I'm trying to determine the number of employees that I should be counting here. Am I supposed to include part-time employees?
Yes, for calculation of your employee count, you should be including full-time, part-time, and independent contractors in that employee count.
Okay. What if I have employees that are located outside of the United States?
They do not need to be included in your employee count, and they're not eligible for inclusion in your payroll costs.
What about if I am a partnership or an LLC? Do I include the actual partners and the members who are the owners of the entity?
This is actually a really great question because the most recent interim final rule clarified that it allows for partners in a partnership or LLCs that are taxed as partnerships to be included in payroll costs with certain limitations, which we'll discuss later, but it didn't specify whether you need to include them in your employee numbers. We're interpreting it, or I'm interpreting it to say if you're including it for payroll costs, then you need to include it for employee count. I will say that if you have not included it, you don't need to amend your application at this point. And if you want to amend your application, if it's going to impact what's been reported to the SBA, you already have an SBA loan number, or it's impacting the amount of funds that you would receive, at this point, it's most likely not possible to actually amend that application.
Right. We've had a lot of our real estate clients have a situation where they do not employ workers directly, but instead have an agreement with a management company, and the management company's employees are the ones providing certain services. How do we handle that? I mean, how does that work?
So we'll discuss management companies and PEOs a little later in the webinar, but the Act does not specifically contemplate management companies. Generally, how we're interpreting it is if a borrower is responsible for the payment of employees' salaries, those funds are coming directly from the borrower has some control over hiring and firing those employees, and the employees are specific to the borrower's business, then those employees are to be included in the employee count and cannot be included as employees of the management company. We have had some questions on agreements where managers or other third parties are providing employees to which a borrower pays a specific rate to that company. So for example, you'll have, in a hotel, some people that will clean the rooms, and the borrower is paying some company $14 an hour for every employee that they provide to the hotel, but in turn, that company is paying the cleaners a separate amount. We don't believe that those numbers can be included in your employee count.
Okay, and then this question goes more to eligibility, but are foreign-owned companies able to apply for this aid?
So that's actually a very confusing issue, and we know that people don't love to hear "we don't know." But the short answer is they're not precluded from applying for a PPP loan. They do need to have U.S. offices, and there are some other requirements. It's one of those situations that will probably need to be looked at on a case-by-case basis, and this obviously discussed with the lender, but generally they are not precluded from applying for a PPP loan.
Okay, thank you. I want to look a little bit at affiliation rules right now. I think affiliation has been a challenging topic for folks applying for the loans and in terms of sorting out the various requirements of the SBA's affiliation rules. The Act made it clear that except for certain limited exemptions, which we'll talk about, the SBA's affiliation rules had to be considered in eligibility, for eligibility purposes under the PPP. And it again falls to the borrower to determine how the affiliation rules affect its application, and in the certifications that we'll look at later in the application, you're essentially certifying to the lender that you've considered these and that based after applying those affiliation rules, you are eligible. So the affiliation rules essentially provide that affiliation exists when one business controls or has the power to control another business, or when perhaps a third party controls or has the power to control two or more businesses. And essentially what this means in the context of the applications is that if one business is deemed to be affiliated with another business, then the employees of both businesses have to be aggregated for purposes of the employee count and also for other purposes of the loan and determining who is the appropriate applicant for the loan. That's a very simplistic example, but it is essentially what the effect of these affiliation rules is. It's important to note that control can be accomplished through both ownership, as in majority ownership interest in an entity, but there are various instances where even minority ownership interest in a business will lead to a conclusion that that business is affiliated with the owner of the interest. Unfortunately, a detailed examination of all the various affiliation rules is a little beyond the scope of our presentation today. The examples given are in the affiliation rules are quite extensive and deal with a lot of different aspects of that. But I guess one of the main precepts is this idea of control of an entity being ownership of 50% or more of the voting stock of that business. So if an applicant owns 50% or greater of the stock or other interest in another entity, those two entities are going to be deemed to be affiliated. The Act does provide for a few exemptions from the affiliation rules, and the most notable of those is that businesses with a North American Industry Classification System code of beginning with 72, which covers accommodation and food service businesses, those are not subject to affiliation rules. And essentially what that means is that each hotel or restaurant location can apply for its own separate PPP loan as long as it has less than 500 employees and is owned by a separate legal entity with its own tax number. They won't have to all be aggregated together as normally would be the case under the affiliation rules. Also, the SBA publishes a franchise directory, and if a franchisee falls within the list of franchises specified in the directory, they will also be exempt from application of the affiliation rules. It's not mentioned here on our slide, but I also want to mention that applicants which are faith-based organizations also get exemption from the affiliation rules in certain limited situations. Allison, I think we're going to address some questions with regard to affiliation.
Doug, yeah, sorry. Could you advance the slide?
Yeah. Sorry about that.
Okay, great. So this, we've received a lot of questions on affiliation, and as Doug said, we don't want to get too far into it just because we know, A, you've probably already filled out your application, and B, it's a very complicated issue. So these are some very basic questions. Doug, when I refer to the word I'm going to, that really means the applicant itself. So does the applicant include employees of a business that has entered into an agreement to acquire?
Yeah, that's an interesting scenario. So if a business has entered into an agreement to merge with another business or to acquire its assets, the SBA will deem those two businesses to be affiliated, and to be will assume that the first business is in control of the second business, as if that was currently the case, even though a closing has not yet occurred. And there are some exceptions to that, but essentially, if you've entered into an agreement to merge or acquire a business, you're going to be deemed to be affiliated with that business.
And these affiliation rules, they're very detailed because in traditional SBA finance, the lender is the one who determines affiliation, but they have put this on the borrowers. And so if an applicant has some negative control rights over another entity, are they able to waive those negative control rights in order to avoid aggregation for affiliation?
Yes, there's been a lot of discussion around private equity firms who obviously hold investments in a large number of entities, and the issue that was hit upon obviously was that because those private equity firms have a lot of negative approval rights over actions to be taken by those businesses, that they were deemed to be affiliated because they had control. That was deemed to constitute control. However, it's been made clear that if the holder of those control rights irrevocably waives them or otherwise relinquishes those rights, then the affiliation goes away and will not be deemed to exist.
Okay. If anyone has any other specific affiliation questions, I would say feel free to drop them in the Q&A. But Doug, I think we should move on to how we calculate the loan amounts for the PPP loans.
Yes. So as we talked about, the amount of the loan was designed to help borrowers cover mainly payroll costs and also some additional expenses. So the basic calculation for the loan amount, as you can see on the slide, is basically the lesser of 2.5 times the applicant's monthly average payroll cost and $10 million. So you can never borrow more than $10 million, obviously. So the calculation, as I've set forth here, you determine the aggregate payroll costs, the average payroll cost. And you can either look at doing that based on the last 12 months prior to the application, or looking at those for the year in 2019. As we'll discuss a little bit later, compensation, cash compensation that's included in the calculation is capped at $100,000. So any amounts of compensation in excess of $100,000 have to be deducted. So once you determine your average monthly amount, then that is multiplied by 2.5 to determine the actual loan amount. It's also worth noting that if an applicant also has an economic injury disaster loan or an EIDL from the SBA that's made between January 31st, 2020 and April 3rd, 2020, that will be added to the loan amount. Let's look next at what uses are allowed for the PPP loan proceeds. Obviously, the payroll costs, and included within that would be all costs in addition to compensation relating to benefits like continuation of group health care benefits during periods of paid sick, medical, or family leave, insurance premiums, and other employee benefits such as that. In addition to these payroll costs, applicants are also allowed to use proceeds of the loan to pay interest on mortgage obligations. However, it cannot be used to prepay any principal on those loans. Also, utilities, monthly utility bills can be paid, monthly rent. And then finally, to the extent an applicant has other debt obligations, which aren't necessarily mortgage loans, they are also allowed to use the proceeds of the loan to pay interest on those debt obligations as long as they've been incurred before February 15th of 2020. And then again, as we noted, if you're refinancing an EIDL loan made between those specific dates, you may also use the proceeds of the PPP loan for that amount. We're going to discuss this in a little more detail later, but one of the interim final rules that was issued basically states that 75% of the loan proceeds shall be used for payroll costs, including the IDL amount. So we'll examine that a little bit later, as that does kind of present some issues of interpretation and concern on behalf of borrowers. Allison?
Thanks, Doug. Would you mind advancing one more slide? So the next we're going to, I'm sorry, you're fine. The next we're going to discuss is payroll costs and what is included in payroll costs. So at this point, there's been a lot of clarity on payroll costs through the interim final rules and the frequently asked questions. We know that you can use up to $100,000 of cash compensation for employees plus the cost of their benefits. So if you have an employee who makes $130,000 a year base salary, you need to cut that down to $100,000, but you can include the cost of their benefits on top of that $100,000. And we now know that you can include partners in a partnership or LLCs taxed as a partnership for, again, that compensation up to $100,000. Also included for payroll costs are certain benefits, group healthcare coverage, including insurance premiums, retirement benefits, payments for vacation, parental, family, medical, or sick leave, payment of state and local taxes assessed on employee compensation, and allowance for separation or dismissal. So what cannot be included in the calculation of payroll costs? So compensation for any employee who resides outside of the United States. So as I said earlier, in order to use that compensation for payroll costs, that employee has to have their principal place of residence within the United States. Federal employment taxes imposed, including FICA, cannot be included in your calculation of payroll costs. qualified sick and family leave wages for which credit is allowed under the Families First Coronavirus Response Act, and then commissions paid to independent contractors cannot be included in your payroll costs. There are some different rules surrounding seasonal businesses. We have had a lot of questions on how to calculate the employees or payroll costs when the business is seasonal. For seasonal businesses, you can use the average monthly payroll for a period between either February 15th, 2019 or March 1st, 2019 and June 30th, 2019. If you weren't in operation for an 8-week period during that time, the business can still be considered if they were in operation on February 15th, 2020, but I don't personally know of many seasonal businesses that are open this time of the year that were not open in February or March 2019 through June of 2019. If you are a specific seasonal business and you have additional questions, feel free to email Doug and myself after the webinar, and we can look at those specific facts and try to help you determine eligibility.
So Allison, you covered this to some extent, but can you summarize again, what exactly is subject to the $100,000 cap?
Sure. So we have to think of that as cash compensation. So salary, bonuses, commission, tips, those sort of cash equivalents that would be paid to an employee. The cap does not include benefits. You can account for those separately, the specific benefits that were included in the Act. You can account for those separately, even if it pushes the quote unquote compensation over $100,000.
Okay. And what about the applicant, the payroll taxes that the applicant is paying? Do those get added in?
It is our understanding that they do not. They do not get added into your calculation.
Okay. And I know this has kind of been a point of confusion for some folks, but I know that I'm allowed to use proceeds from the loan to pay various expenses, rent, utilities, interest on debt obligations, et cetera. But is that, does that enter into the calculation of the loan amount?
It doesn't. So the loan amount is essentially 2.5 times your payroll expenses. Since the loan amount is supposed to be used, for forgiveness purposes, within this 8-week time period, the amount, that 2.5 times, the 2 would cover your 8 weeks, and that half would be the extra for your other expenses that are allowed under the Act. We understand for most borrowers that 0.5% is not enough to cover the totality of their rent, utilities, and debt interest, et cetera, but that we believe that was the theory behind the 2.5 times payroll expenses.
Gotcha. And then we had one client ask whether they could include as part of compensation parking fees, daily parking fees or monthly parking fees that they reimbursed employees for or paid them as part of their compensation. Could that be included?
So I've seen this question quite a bit, and to be a typical lawyer, I would say it depends. No, there are mixed responses on this. I personally tend to be a little more conservative in my approach, and I would not include parking fees for employees as a part of their compensation, since the benefits listed are pretty specific. There is an argument to be made that it could be a part of their cash compensation, but personally, I would err on the side of not including those costs.
Yeah, I think it's probably always a good idea to be on the conservative side in your interpretation of these things. I totally agree with that. Well, we're going to look right now at some of the changes that have kind of evolved to the PPP since it was originally enacted. I'm going to skip over the first one here for a second, which we'll treat in a little bit more detail. But I think most people are aware of sort of the transition in the interest rate that is being charged on the loans. The Act originally stated that it could be up to 4%. SBA information sheet that came out said that it was going to be 0.5%. And of course, everybody got excited about that. But then when the interim final rule came out, it said that interest would be at 1%. And that is, in fact, what we're seeing in the actual loan, the loan documents. Likewise, the maturity date, the act there just said it could be up to 10 years, but the interim final rule established that the PPP loans would be fixed at 2 years. And then again, loan deferment. Originally, the act just provided that it could be up to 1 year deferment of payment of principal, but the interim final rule established that the period of loan deferment would only be for 6 months following disbursement of the loan. And again, during that time, interest will accrue on the loan. And it's also important to note that the 6-month deferment period is part of the 2-year term of the loan, dating from when the loan is originated. We're also going to talk a little bit later about an applicant's use of a professional employment organization, or PEO, that handles its payroll. But that's also been a development that has helped interpretation of the underlying act. So let's talk a little bit about what we're referring to as the 75-25 rule. So this has to do with use of the proceeds of the loan. And the original act, in terms of, other than specifying what the proceeds could be used for, it did not lay out a specific percentage that, you had to use X amount for X percentage. The SBA then issued an information sheet which suggested that not more than 25% of the forgiven amount may be used for non-payroll costs, that being the various expenses, rent, utilities, interest, et cetera. Then we had the interim final rule that came out and specified that at least 75% of the loan proceeds shall be used for payroll costs, as opposed to just using 75% for calculation of loan forgiveness, which we'll talk about in a few minutes. So that has kind of led to a lot of confusion among applicants, because the interpretation of that, if you give it a literal reading or conservative reading, is that you're going to have to use 75% of your loan proceeds strictly for payroll costs. That could obviously present some issues for borrowers once they have the loan proceeds. Allison, do you want to talk a little bit about that?
Yes. So the 75-25 rule has thrown some borrowers for a loop, because they went ahead and filled out their applications, and then this interim final rule came out to say that they shall use the proceeds 75-25. So we're taking, even though like I said before, I tend to be more conservative in my approach. I don't believe that any borrower, or that many borrowers, could say with certainty that they will be able to use the loan proceeds 75% for payroll, given several circumstances. One, they've probably already laid off several people. They don't know if they'll be able to bring them back in time, which is June 30th. We'll discuss that later. Two, they don't have control over whether the employees would even want to come back. We've heard a lot of stories of employees collecting unemployment and not wanting to actually come back to work. So we're telling borrowers that with this rule, keep in mind that we know it, as it's written, we know it will impact loan forgiveness, but that borrowers should strive to use the loan 75-25 but we're interpreting it to be that the quote unquote unauthorized purposes of the loan would be for uses outside of the approved list, and that the 75-25 rule will hopefully only impact the forgiveness portion, since it's very hard for a borrower upfront to certify that they are going to be able to use those loan proceeds in that way. And we also believe that if loan proceeds are left over after this 8-week period, we're unsure of when the SBA is going to require that you apply for forgiveness, but that the worst case scenario would be if you didn't use it in those 75-25 split and those loan proceeds were left over, the idea would probably be that those funds then have to just be paid back immediately versus amortized over that 2-year period.
Thanks. I think we've sort of addressed these questions in your discussion, so we'll move on to the next topic here.
Okay, so I'm going to discuss the use of PEOs. We did have that brief conversation earlier around management companies, and PEOs are different, but we were glad to get this clarity because we had a lot of questions on the subject. If a borrower uses a PEO or other payroll provider, and I emphasize other payroll provider, then the documentation provided by that company is sufficient for the employee and payroll information that you are submitting to the lender. I emphasize other payroll provider because this opens the door for a lot of our clients who had questions on what happens if a management company is used for employees and therefore processes the payroll. I did go through earlier some of the criteria that we believe would impact determining if those employees were in fact employees of the borrower or employees of the management company, and if you feel as those criteria as a borrower, you would hold those employees as the employee of the borrower, then you would also obviously use those employee costs as costs of the borrower. Okay, we did put in the application process originally when we were doing the webinar. Obviously, funds have run out, so this may be moot, so I'm not going to spend a whole lot of time on this. If more funds are allocated and you have not yet applied, you would apply with the SBA form application, which could be integrated directly into the lender's website, or you would fill out the application. You have to provide certain documentation to your lender. But I believe most people at this point have probably already applied. Through the application process, we did have several questions that came up. These were just snippets of some of the more quote unquote problematic questions that came up in the application. If you are as hopeful as we are that more funds will be allocated and you have specific questions on the application, feel free to drop them into the Q&A, which we will do our best to answer. We do see a lot of questions coming in, or email us separately after the webinar. Also, as a part of the application process, the borrower has to make certain certifications. We've gone ahead and just clicked out the certifications right here in the slides so that you can go back to them quickly if you have questions. But obviously, we would advise all borrowers to make sure you can read these, to make sure to read these certifications and feel confident in certifying to them. One thing that's a little odd is that it references the Paycheck Protection Program rule. We believe this is, a combination of the Act, the interim final rule. Consult if you have questions on the applicability of that. And then the next slide too, these are additional certifications. The one we heard the most concern about was the current economic uncertainty. As an applicant for a PPP loan, a lender and the SBA is going to assume that you have been impacted by the coronavirus. We think it's safe to say that every borrower who is applying for these loans has some economic uncertainty. the only borrowers we would dissuade from applying or from making the certification would be if for some reason your business is very is booming because of the economic climate right now. You probably wouldn't feel comfortable making that certification. And Doug, I think that, go ahead.
Yeah, I was just going to say we're going to skip over these questions, I think, in the interest of time and making sure we have enough time left to cover the forgiveness aspect here.
Absolutely.
So I want to say one word quickly, though, about funding of the loans. Once a loan has been approved by the lender, they are required to make the first disbursement of the loan amount no later than 10 calendar days from the approval. So that's sort of the process of funding that they're required to abide by. And as of course we mentioned, the entire $349 billion appropriation amount has been allocated, and we will be waiting with patience to see what happens with additional appropriations. And just on the slide, you'll note too, we've included, there is a website which is based on self-reporting of businesses who've gotten their PP loans approved. So that might be of interest to you as if you're going through this process. But let's move on to the loan forgiveness aspect of the PPP loans. Obviously, one of the big benefits to this loan program was that the borrowers had the ability to have potentially all of the loan forgiven. As we got more into the details of how this would work, it maybe looked a little bit less promising than it initially did. But I wanted to point out that we do not yet have official guidance issued by the SBA on interpretations of this portion of the Act. So we're hoping to get a lot of the concerns and questions cleared up as part of that process. But, you know, essentially in determining how much of the loan a borrower will get forgiveness on, it's going to be based on how much of their loan funds are used in the 8 weeks following the date the loan is funded. And in order to maximize forgiveness under the loan, a borrower will really need to use all of their loan funds, 100%. And as we talked about, the target probably needs to be 75% for payroll and 25% for the other approved expenses. But in any event, the idea is to use all of those loan proceeds within the 8-week period in order to have the best chances of maximizing the forgiveness amount. The lender is typically going to require various documentation from the borrower to support their request. Those are listed a little more particularly, I think, in the Act, but obviously it's payroll documentation, payroll filings with the IRS, state income tax, payroll filings, and other evidence with regard to unemployment insurance filings and related information. So essentially, once the borrower provides all of this information, the lender has 60 days to issue a decision about loan forgiveness. So depending upon when your loan is funded, you've got 8 weeks to spend the money. Then you're going to go through the process of proving to the lender the amount that you should get forgiveness on. So again, this is a pretty fast process, which is what it was designed to be. Let's hope that it actually works in practice. as well. And then I also want to highlight the fact that under the Act, the amount of the loan that's forgiven will not be considered income of the borrower and thus will not be taxed. So that is another benefit to this. The next slide, we talk and give examples about how the amount of loan forgiveness is actually calculated. And it's important to realize that the amount of forgiveness that you would otherwise be eligible for will be reduced if you have had a decrease in the number of employees since the dates you use for calculating the payroll amounts, and then also if you have reduced salaries for employees. And without getting specifically into the actual calculations, which are listed here on the slide, just know that has to be factored in, and there's going to be a percentage reduction, based on a reduction in number of employees, and then with regard to reduction in pay, if it's a reduction in excess of 25% of the compensation in the most recent full calendar quarter in which the employee was paid during an 8-week period. So you only get nicked in that case if it's in excess of 25% of what they were making. So it's important to factor these things in. Obviously, the intention was that the government was hoping that this would help employers not to fire people, not to let people go, and not to reduce salaries. However, if in fact they have done that, there is a provision of the Act that says that those reductions in number of employees or reduction in salary that took place from February 15th to April 26th of this year will not be considered and not be applied to reduce the loan forgiveness if the borrower rehires those employees or brings back their pay by no later than June 30th of this year. So there's a way, if in fact that has actually been done, to reset the clock, if you will, and be able to qualify for a larger portion of loan forgiveness.
And Doug, I do want to just chime in there to say that we do know of several lobbying agencies, if that's what you would call them, who are trying to work with Congress to get some of those provisions revised, because practically speaking, many borrowers and many businesses are unsure if they would be able to bring those employees back by June 30th. And we're hearing a lot of, well, do I bring them back by June 30th and lay them off July 1? We don't believe that was the intent of the Act. And so we're hopeful that the use of proceeds will be extended beyond that 8-week period in terms of forgiveness to allow companies to bring employees back. And then also for the use of the funds themselves, it's a little unclear whether those funds need to be used within 8 weeks or just whatever is used within that 8-week period gets forgiven. We're hoping that they'll provide some more clarity to extend that 8-week period and extend the June 30th date, as there doesn't appear to be much ramp up of the economy that could allow borrowers to restore their employees to their fullest capacity by June 30th.
Right. I think it'll be interesting to see in the latest appropriation if any changes are worked into the existing Act at that point too.
That's right. And you addressed a lot of these common questions, and I do see a lot of questions coming in over here in the Q&A. So I'll just pick a few of these common questions that we have typed over here so we have time to answer some of the more specifics. But what types of loans are included in the covered mortgage obligations definition?
Yeah, the covered mortgage loan or covered mortgage obligations includes loans that are both secured by a mortgage on real property, but also by a lien on personal property. So if a business may not have real property, but they have a loan that's secured by like all of their assets, office equipment, accounts payable, et cetera, those types of loans, paying the debt interest on those types of loans will be included in the calculation of the debt forgiveness, but not unsecured loans.
Understood. And I particularly had a lot of questions from my clients asking me if, they've already come out of pocket for some of these payroll costs. Are they allowed to reimburse themselves for those costs that they incurred prior to receiving the loan in order, and if so, will that be included in the forgiveness calculation?
Our understanding of the wording of the act is that it will not be. They may not use the funds to reimburse costs prior to that 8-week period.
Okay, I agree with that.
And I also want to point out, too, that with regard to using the proceeds of the loan for rent, utilities, and the covered mortgage obligations, those all have to be pursuant to agreements or accounts that were in existence prior to February 15th of this year. So that's just something to remember as well. Well, let's move into the questions then.
You want to start with the first, Doug, or you want me to go ahead and move through it?
You can go ahead.
Okay, great. So we got a question. For the purposes of eligibility, loan proceeds, and forgiveness, how do I count occasional employees, such as those I bring in to help for banquets, meetings, events, et cetera, that occur sporadically? We would think that using the employee calculation of either over the past 12 months or calendar year 2019 would average out those employees in terms of eligibility for loan proceeds, since you're using 2.5 times your average monthly payroll. As far as forgiveness, that those occasional employees would be a little more difficult to say whether you've had a change of employment, but they will look at the change of employment. I believe it's from February 15th through April 26th. They won't take, and Doug, correct me if I'm wrong, but they won't take into account that change of employment. They will just look at the change of employment at June 30th from what it was within either the calculation of end of the year 2019 or the past 12 months average.
I believe that's correct, yeah.
Great. So, and if we don't answer your question fully or you have further questions, Doug, if you advance one more slide, our contact information is there and you can email us after the presentation.
So one of the other questions we have here is sort of a differing interpretation on why independent contractors are included in the employee count. Allison, are you able to respond to that one?
I'm sorry, Doug, did you ask?
Yeah. So
I didn't know if you, I'm sorry. Go ahead.
The question was, could we provide a little more clarification on our interpretation or source for why independent contractors should be included in the company's employee count? And I don't recall right offhand where that's contained in terms of counting, unless it's the original act. we can certainly look at that in a little bit more detail and respond. So let me, we'll revisit that question. I think we're having a little bit of technical difficulty with Allison.
I'm sorry, I'm having some technical difficulties with hearing, so I'm just trying to resolve them. If you just give me a moment.
Sure. I apologize. I'm scrolling through the questions here as well. This is a good clarification on a point about gross payroll and calculation of the loan amount and the payroll cost. Gross payroll includes employees' withholdings, but the applicant is not allowed to include the employer's portion of that. So thank you for that clarification. One question we had was inclusion of the group health care benefits. Is it purely health / medical plans? And does that mean it just excludes dental, vision, life, disability insurance costs? To my knowledge, it should include all of those related type coverages. I'm not aware that those are excluded.
And Doug, I'm sorry, I'm back. I would agree with that.
Yeah. Another one of our listeners asked, borrowers that have filed an application but not yet gotten an award letter will they most likely not get a PPP loan? I guess that remains to be seen. My understanding in some cases is that lenders, once there has been an additional appropriation, lenders will go back to the applications that have been filed. But until that happens, those are kind of in limbo. But I do think, based on what I've heard at least, that they will go back to those applications and that those applicants won't have to reinitiate applications.
That's similar to what I've heard as well. I see, and I apologize for blipping out there, so I'm not exactly sure which questions were answered. If I repeat one, I apologize, but I I see a question here. I have a question on the 75% issue. The guidance you are referring, you say that you cannot use more than 75% of the loan amount for non-payroll costs. And some speculate that if you do exceed that percentage, you would not be eligible for forgiveness at all. Thoughts? My personal thoughts here would be that you would be, if you exceed the 75-25 rule, your forgiveness would be limited. It would not be that you would not be eligible at all. It would just be reduced by the formula or whatever the additional guidance would say, since the original Act's formula did not take into consideration the 75-25 rule.
And this is an interesting question about the application form. What if the bank application did not have a way to address the 100,000 salary cap in the calculation? The bank system automatically calculated the loan amount based on payroll reports supplied and didn't exclude payroll over the 100,000. I feel like that's something we probably would have to take up directly with the lender. I mean, if they didn't exclude payroll over the 100,000 cap, I would feel like you would need to point that out to them and work with them to resolve that, so that you're not running afoul of any certifications on the applications. Allison, do you have any thoughts on that?
Yeah, I would also say it's very strange that a lender would calculate that loan amount, because as we understand it, the loan amount calculation is a borrower responsibility, and the lender is not responsible to go back and necessarily perform any severe audit on that loan amount calculation.
And here's a good question we didn't get into in much detail, but in terms of calculating the forgiveness amount, the Act talks about what is it? The full-time equivalent employees. And the question is that based on 40 hours, 32 hours, or 30 hours? I think you have a better handle on what's out there on that, Allison, if you don't mind.
Yes,
answering that one.
absolutely. Sure. So in terms of the PPP loan program, they have not issued a definition of full-time employee. Where we do see this definition used is in the Affordable Care Act, which uses a 30-hour standard. We know that people would love for us to give black and white answers, but unfortunately, since a full-time equivalent employee definition has not been issued in terms of this program, we are sort of forced to look at the only full-time equivalent definition that we have, which would be 30 hours. We have heard that it's potential that they would use 40 hours, but for now, I would say that we stick with the definition that we do have, which is 30 hours, until that loan forgiveness guidance is issued, which hopefully will include a definition of full-time equivalent employee.
Another question we have is, can we use 100% of the loan proceeds toward payment of payroll? Will it be forgiven? I can't imagine that would be an issue, but Allison, your thoughts?
Yeah, I agree. When they issued the additional guidance, they had set that 75-25 rule, and they had provided some thoughts on why they issued that quote-unquote rule, and they said it was because the spirit of the act was to keep people employed. And so if you forego paying your additional costs and allocate all of that towards your employees, I think that would be forgiven. The original intent was that no more than 25% of your loan be allocated for non-payroll costs.
Another question, if a company needs to give money back because they oversubscribe, will they also have to give back money if they drop their head count? Again, I think in terms of the loan forgiveness portion of it, that's if you drop the head count, it's going to affect the amount of the loan you can be forgiven for, but that does not give rise to necessarily to a requirement that you repay that money. It would just, any amount of the loan that's not forgiven, you know, obviously then just becomes repayable pursuant to the terms of the note.
I think a similar question comes next where it's, so sorry, my questions just moved. Is rehiring or maintaining the payroll tied to number of employees or / positions or named individuals? For example, hire back the same individual we laid off or rehire the position, any new employee. So our understanding is when it comes time for forgiveness, there'll be like a separate application that needs to be made to the lender. We know that it's going to be challenging for people to maintain the exact same staff they had previously. Upon layoff, they may have taken another position. They may no longer want to work for the company. So I believe the intent is to tie it to the number of employees and positions and salaries. So if you in turn laid off 10 people, their salaries were each $100,000, and you bring new people in and you pay them $50,000, I think that there will be some calculation done. And again, I can't speak with any certainty because we don't see the forgiveness guidelines, but I think there would be some adjustment to your forgiveness amount in that scenario. But I would think that you could just replace those positions, you know, to bring your count back up to its original count, and also, you know, document this information when you're submitting to the lender if they have questions as to why certain individuals were not rehired and instead replaced with new employees.
This is another question about the loan forgiveness. Will bond interest expense be available to use for forgiveness? 501c3 hospital revenue bonds, taxable and tax-exempt portions. I think it, again, we'll go back to depending upon whether those are secured by any assets or repayment of those are secured. And I'm not familiar enough with that area of bond law to know that, but there is that limitation on the forgiveness aspect. You could certainly use the proceeds of the loan to pay that interest expense, but I'm not entirely sure that it's going to be factored into the forgiveness formula unless that obligation is secured.
I see another question here. What happens if we recall employees and our count goes over 500? So that 500 number, if you calculate your employees based on the average employee count for, you know, the 12 months prior or end of year 2019, or calendar year 2019, and you hire more employees than you originally had, and now you're over the 500 limit, I don't think that would impact your forgiveness capabilities. You are providing more jobs, and when you apply for the loan, you did meet the 500 or under standard to be eligible.
can new hires be included in payroll calculations for loan forgiveness? I think the way the calculation works, if you're adding employees, I mean, that should be to your benefit if I'm thinking about it in the right way, and that the requirement for the calculation you would be. I mean, those would factor in. Am I looking at that right, Allison?
Yes. When you're calculating the employees, you're using the average, not employees, excuse me, the payroll cost. You're using the average payroll cost for either calendar year 2019 or the previous 12 months. So those new hires would be reflected, if let's say you used the prior 12 months, they would be reflected in your calculation of the loan amount. Also, that 12-month period will take into account that during that time you have fired people and hired new people. If you're asking if you hired somebody within the time period not included in the payroll calculation, can you still use loan proceeds to pay them? I would believe the answer to that question would still be yes.
I think that's about all the time we have for questions today. Although I appreciate all of the very thoughtful questions that we are getting. We will be able to review those following the webinar, and can hopefully respond to those that we were not able to address. But I want to thank everyone for joining in and listening, and appreciate your time. And thank you, Allison, for all the great information you helped to provide here.
Thank you, Doug.
Great. Thank you, everyone. We appreciate you spending this time with us. We'll be sending a follow-up email with information on continuing education credits, the webinar recording, and the contact info for our presenters. So please be sure to reach out with any questions you may have on this or any other topic.